You get the News and Observer right here on the front page of the News and Observer. Is the instant topic about which our speaker has spent 4 or 5 decades of his life promoting, and he's going to talk about the importance of public records today. And Hugh, I want to make sure that we've got you there. I do see you that you have made it, and at our generation, anytime that we master the Zoom moment, then we are happy about that. But at any rate, Hugh Stevens, he is a superstar in his realm, and he changes the life of those of us who are able to live here in a world where we are able to know a little more about how our governments operate. He's a fellow Tar Heel, a nationally known First Amendment and media lawyer, and has led cases that made headlines within the last month, culminating battles with our own university to release public records of its business records as required by law. And he's been in the news this week because just this week, within the last month, on January 11th, after 4 years, the United States Supreme Court found for the Daily Tar Heel that Hugh was representing and other area media in Hugh's public records lawsuit for records of students found guilty of serious sexual offenses. 21 days later, the UNC system settled the Daily Tar Heel lawsuit against it, and the Board of Governors as well, over its agreement with the Sons of Confederate Veterans, embarrassing the Board of Governors members for misleading the public about it. And that's what's in the News and Observer today. And although the Silent Sam matter was politically charged, that Hugh has nothing to do with that. He is a lawyer who is a campaign for open records, was very active also in representing the state's media and the university's athletic academic scandal that went on for so long here just a few years ago. Hugh was general counsel of the North Carolina Press Association for 20 years until he retired in 2002. Except Lynn, his retirement was a fraud, as you will hear. He has received about every award that he could possibly receive, as he has been accorded. He is in the North. He is the only the second lawyer who has ever been inducted into the North Carolina Journalism Hall of Fame. He also is a teacher, having taught at Duke's Sanford Institute of Public Policy. So we've got Duke well represented here today. And Kathy, we're so happy to have you here, and you can come cheer for the East Chapel Hill Rotary Club anytime. At any rate, he had taught at the Duke's Institute of Public Policy until also that same 2002 retirement, but then he lives in Raleigh and still teaches a First Amendment course at North Carolina State. He was editor of the Daily Tar Heel, fighting to overturn the North Carolina's notorious speaker ban law. And then he spent 4 years in the military as in the U.S. Navy JAG office. Well, I could go on about his community leadership, his Episcopal Church, his nonprofit work. He has been chair of the UNC Friends of the Library. Plus, he and Marilyn are fun on top of all that. I don't know how they find time. They are bird watchers devoted to the Boston Red Sox. So at any rate, in short, he's a remarkable man, and I appreciate his giving his time today to speak with us on the issues involved in his profession. So welcome, Rotary, to a Tar Heel born and a Tar Heel pain in the side of the university that he loves, Hugh Stevens.
Welcome.
Oh, thank you, Jim. It's very kind of you. You know, I feel like it was well worth my time to be here just to hear Dr. Thomas. What a wonderful description of her life and what she's accomplished. Congratulations to you, Doctor, and also to your club for recruiting her to be a member. It's just terrific. Yeah, I'm going to talk about, start off just talking a little bit about what's behind public records and open meetings laws. We need them because they underlying both is the fundamental principle that as citizens in a democracy, we are supposed to educate ourselves and take positions about public issues and be involved. But it is fundamental that you can't form an opinion about something if you don't know it's happening. And we don't have any inherent constitutional right in North Carolina to access the meetings or the records of government at any level. Without the public records law and the open meetings law, any public body, a county board of county commissioners, a school board, a city council, whatever, could just meet whenever they wanted to, do whatever they wanted to in the dark, and only disclose what they chose to. So these legislative enactments are fundamental to our right as citizens to know what government is doing to us and for us and what they're doing with our money and so forth. They're pretty obvious what they mean. The open meetings law is what it says. Its fundamental requirements are that public bodies meet in the open, that they have allow people to come and participate and see what's happening. It prohibits secret ballots on the part of members of public bodies. It basically gives you access to the meetings and proceedings of government bodies at all levels. And of course, the public records law is pretty fundamental. Ours is a strong policy based on a strong policy statement that says the records that are made or received by public officials in North Carolina at all levels are the property of the people. They don't belong to the public body. They don't belong to the politicians. They don't belong to the office holders. They belong to us. And so over time, it's been my role to both lobby for improvements in both of those laws and to litigate a lot of cases to try to enforce both of those statutes. As it happens, the ones I'm going to talk about in just a little while, one is a public records case, the other is an open meetings law case. But I'd like to give you just a little bit of background about the most important public records case and explain a little bit about how the law gets shaped and construed in ways that make the law effective. It's the case called News and Observer versus Poole. And the Poole case began in January of 1989 when a book jacket was leaked to the News and Observer. Not a book, not a manuscript, a book jacket. And the jacket purported to be forecast the coming of a book by a fellow named Peter Goldenbach, who was going to reveal all manner of underhanded and improper and illegal things going on in the basketball program at NC State. Jim Valvano was the basketball coach. He was also the athletic director at the time. He was paid the princely sum of $100,000. And in fact, he was only paid that to be the basketball coach. He was paid nothing as the athletic director. But this book jacket suggested that there was a coming book that was going to reveal very, very serious and controversial practices and academic fraud and so forth in the NC State basketball program. Well, a big outcry ensued, including an almost tearful press conference by Valvano where he denied all of these possible suggestions of impropriety. But it resulted in C.D. Spangler, who was then the president of the university system, creating a commission of 4 distinguished North Carolinians to look into the basketball program at NC State. And it was called the Poole Commission because the chair was a lawyer from Southern Pines and a former chair of the Board of Governors, Sam Poole. Now, I want to be full disclosure, Sam was and is one of my longtime closest friends. We have played golf together all over North Carolina, Virginia, Scotland, England, you name it. He is just one of my really, really good friends. He was the chair of the commission. The 3 other members who were appointed were equally distinguished. Cliff Cameron, who was the retired CEO of First Union Bank in Charlotte, was one. Bill Klopman, who's retired CEO of Burlington Industries, was the third. and Dean Colvard, who had been the first chancellor of the University of North Carolina at Charlotte, was the fourth member. So during the spring and summer of 1989, they set about investigating the basketball program at NC State. Well, now clearly these four people didn't have investigative skills or anything of that sort. So what did they do? They asked Lacey Thornburg, who was then the Attorney General of North Carolina, if they could borrow some SBI agents. And so he sort of loaned 3 SBI agents to the commission to conduct the investigations. And over the ensuing several months, they interviewed 160 people about the basketball program and they returned the interview notes and the documents that they gathered up to the members of the commission. And the commission compiled a report about it and was prepared to present it to President Spangler and the Board of Governors. Well, when we got to about the time it became pretty clear that the commission was going to report in, Frank Daniels Jr. Asked C.D. Spangler for copies of the records in advance. He said, when this is presented, we think it ought to be a public presentation and the record should be made public. And so I'm asking you to turn them over to us. And Spangler said, Frank, I don't have them. Now, it helps to understand that Spangler and Frank Daniels were very, very close friends, having gone to Woodbury Forest together as young men and having been through UNC together. But so basically, President Spangler said, I'm sorry, you'll have to ask Sam Poole. I don't have the records. So in due course, Frank asked Sam, and up pops Andy Venori, the Chief Deputy Attorney General of North Carolina, who steps in and says, oh no, these are not public records. This is all confidential. You can't see any of this stuff. And so then in late August of 1989, there was a presentation made to the Board of Governors by Sam and by President Spangler. And it basically, the commission report, what was told was, they found that Valvano had done some things that were not proper, but they were more involved with violating the spirit of the law than the actual law. And that the real problem in the basketball program was a serious lack of supervision from the top, and that he was simply doing what his superiors either asked him to do or allowed him to do. So they made this presentation, and just about the same time, the Golden book finally came out, and it was just as scurrilous and as damaging and as it had threatened to be. And it talked about that it alleged that players had used drugs, that boosters had given gifts to players, players' grades were changed to keep them eligible. And it also reported that the team was rife with morale and racial issues, and that Valvano was not a very good hands-on mentor for the players. So after in the same week that the book came out, and the report was made to the Board of Governors by Spangler, then Chancellor Polton, who was the chancellor at NC State, resigned. And then in a public proceeding, President Spangler told the Board of Governors that he was going to ask Valvano to step down as the AD, and that he was going to refer some of the findings of the Poole Commission to the NCAA so that they could conduct an investigation, which in fact happened. And all the time we were continuing to ask for the records of the Poole Commission, now that the report had been rendered to the Board of Governors, and they had reviewed it for 3 hours in a closed meeting that was not open to the public. Finally, in October of 1989, Frank said, okay, sue them. So we did. We sued over the public records law. And we, Andy Venori defended the case. Well, meanwhile, as the case unfolded, Valvano stayed on as the basketball coach through the 89-90 season. They finished 6-8 in the ACC, but even though they had some really good players like Chris Corciani and Rodney Monroe. But finally, because of more and more accusations that have come out, not only from the Goldenbach book, but from other sources, including a player who claimed that he had been paid $65,000 by a booster. Valvano resigned in April of 1990. He took a settlement of about $250,000 from the school and another $350,000 from the Boosters Club, and he left. So finally, we get to court in April of 1990. Holton is gone. Valvano is gone. Everything has changed, but the lawsuit's going on, and Superior Court Judge Henry Barnett ruled in our favor. And the key ruling that he made was that even though the SBI agents had compiled the records for the commission, they were not SBI records, which would have been exempt from the public records law. They were pool commission records, and therefore were public and had to be turned over. Well, frankly, at that point, I thought, why would they appeal this? I mean, it's after all, Valvano's gone, things have changed, but they did. And so it wasn't until January of 1992 that the North Carolina Supreme Court heard oral arguments in the case. And it wasn't until November of 1992 that they ruled unanimously in our favor. And the key point of the ruling was not only to uphold Judge Barnett in all respects, including his determination that the records were not SBI records because they had been compiled on behalf of and at the behest of the commission. But they also went on to make another ruling, and that's the key ruling in this case, and that is they ruled that the public records law is to be construed liberally and expansively in order to accomplish its purposes, and that any exemptions or exceptions are to be construed narrowly. And that ruling was really what we took away from the Pool Commission case. And it has been the linchpin of all of the litigation that I've been involved in since. Because what the court did was to construe the law in a way that really made it effective. And that is what was really important. And the irony of that, there's two ironies about this. One is that I later found out that in the summer of 1989, I had invited Sam Poole to go on a golf trip to a condominium that my wife and I owned in Wintergreen, Virginia. And he asked me to pick him up at the Consolidated University offices in Chapel Hill because he had a meeting that morning. And I would drive up. So I arrived at the appointed time, and Sam came out of his meeting, and he put his golf clubs and his suitcase and his briefcase in my trunk of my car. And we went off to Wintergreen and we played golf for 3 or 4 days. And I later found out that that was the day he had presented his findings of the commission to Spangler. He had offered him the documents, and the President Spangler said, "I don't want them, you keep them." And so they were in the briefcase and had been in the trunk of my car the whole weekend. And it was only 2 years later that we got a ruling that said they were public documents and we were entitled to have them. The further irony is that so much had changed in the terms of the facts underlying the case in the meantime that no one ever asked Sam for the records. There was no reporting done about the contents of those records to this day. So what we took away from the Poole case was a great result, but no records. So that's a background, and it explains why we have then pursued dozens, literally, of cases against public officials at all levels ever since. I've sued governors, I've sued city councils, and yes, we've sued the university over several matters. And the most recent ones are the ones that I think Jim wants me to touch on and then answer some questions about. The first one he mentioned is pretty straightforward public records litigation, and that is, for years, the Daily Tar Heel had sought information about students who, under this administrative process known as the Title IX process in the university, had been found culpable for serious sexual offenses. And these are very serious sexual offenses. Many of them would be felonies if they had been prosecuted in the court system. But instead, the federal government has imposed on universities the responsibility to handle these sexual assault and sexual misbehavior cases, which in my view, they're very ill-equipped to handle, but they do. And so some number of students, the Daily Tar Heel believed, had been expelled or suspended or otherwise punished for this sexual misconduct. And after asking for years for the information about who these students were and what kind of punishments were administered, they finally, the editor, Jane Wester, decided that enough was enough. And so we filed a lawsuit under the public records law in November of 2016. We lost in the trial court. We won 3-0 before a panel of the Court of Appeals. The university appealed to the North Carolina Supreme Court. We, in last May 1, 2020, we got an opinion 4-3 in our favor from the North Carolina Supreme Court. The university then filed a petition for writ of certiorari asking the US Supreme Court to review the case because it involved an interpretation of the interface between the North Carolina Public Records Law and a federal statute, a federal privacy statute known as FERPA, the Federal Educational Privacy Act. And they were asking them to review it on the grounds that it involved a federal issue. And finally, on January 11, the court denied that petition and the case was over. So that litigation lasted more than 4 years. And to try to unlock the records about these sexual predators, people who had committed very serious sexual offenses. The other case, of course, is an open meetings law case, and it came about in November of 2019 after the university system announced that they had reached a settlement with the Sons of the Confederate Veterans over the Silent Sam issue. And you may recall that there were two pieces to this settlement. One was that they were going to create a trust of $2.5 million for the Sons of the Confederate Veterans to take charge of Silent Sam and provide housing for it to keep it in good repair and to take care of it and protect it and so forth. And then the other piece was that they had paid the Sons of the Confederate Veterans $74,999 to curtail their First Amendment activities on the UNC campus and not have demonstrations or parades or bring Confederate battle flags and so forth. Well, as you will recall, there was an enormous outcry from alumni, faculty, students, friends of the university, all about these settlements. The idea that the university system had ordered Chapel Hill to give $2.5 million to the Sons of the Confederate Veterans in this trust agreement, and paid them almost $75,000 under a second agreement, was really stuck in the craw of a lot of people, particularly Black alumni, but not just Black alumni. Many people were very, very upset about this. So it came about that in early December 2019, there appeared in the News and Observer an op-ed signed by 5 members of the Board of Governors saying, well, we negotiated these deals for the good of the university. It'll keep Silent Sam away forever. We'll never have to deal with them again. And this was a good deal. And we negotiated this agreement. And it was signed by 5 members of the Board of Governors. Bob Rucho, Jim Holmes, Anna Nelson, Wendy Murphy, and Darrell Allison. And it also revealed for the first time the $74,999 settlement. That wasn't even disclosed until the op-ed appeared. So the Daily Tar Heel editors read that, and I read that, and we came to the conclusion that if it were true, and we certainly assumed it was true, we didn't expect that 5 members of the Board of Governors would voluntarily publish an op-ed over their names that wasn't so. It indicated that these 5 people had very likely violated the open meetings law because they were never given notice of a meeting. They had never kept any minutes. There was nothing to indicate when, where, and how these proceedings had occurred. So we filed suit to enforce the law, which allows a court to set aside some action taken by a public body if it's taken in violation of the open meetings law. Well, if you've been reading the news or hearing the news this week, you know that at the end of the day, it turns out that the op-ed was not true. It was a PR stunt orchestrated by the communications director for the UNC system, who essentially borrowed the names of these 5 board members and wrote and published this op-ed to try to put a good gloss on what had become a very, very controversial, both settlements had become very controversial. And then to wrap up, of course, you know that a few months later, the $2.5 million trust was set aside by Judge Badur on the grounds that the Sons of the Confederate Veterans did not have standing to sue the university. There was no basis for them to enter into a consent judgment with the university. And so that was set aside. But the smaller settlement, the $74,999 settlement, remained a mystery. How did that happen? How did it come about? Well, this week we found out. And we found out that it was 4 lawyers who got together and cobbled up the agreement and drafted it and presented it to then interim President Bill Roper, and who signed it. And so what the open meetings law case did was to finally shine a light on what had been a very dark corner of the proceedings with the university system with respect to Silent Sam. So now we have much more of the story. There are still questions lingering out there, and you may have some of those, and I have some. But anyway, that's a long tale that tells you about how the laws work and why they are important and what we've been doing with them most recently. And I hope that you all will appreciate the fact that, first, that we have these statutes, because if we didn't, a lot of government would happen in the dark and we wouldn't know about it. And also, I hope you'll realize that the news media, and in this case, particularly the Daily Tar Heel, enforce those laws on your behalf and on the public's behalf. So thank you for the time to tell this story. I'm happy to answer any questions and have a nice conversation about any of these matters as long as you like. Thank you again for having me here.
Mr. Stevens, thank you so much for sharing with us. That was really very interesting, an excellent presentation. We do like to ask questions in this club. We always have some great conversation that comes from those questions. Folks, if you'll use the raise your hand feature on Zoom, or if you're unable to locate that, you can chat down there and I'll call on folks on the order that they were received. But I see that Ron Link has a question.
Hey, Hugh, thanks for your presentation. That was terrific.
Hey, Ron, good to see you. Long time no see.
Yeah, good to be seen. Good to be seen.
How's your golf game?
It's okay. I play more tennis than golf now. But I shot my age at Finley a couple of months ago, so I'm feeling pretty good about it.
Anyway, what's your question?
Two subsidiary questions on the Silent Sam thing. One, that 74,999 figure. I look at that and think, well, there must have been some reason they wanted to keep under 75,000 even. So my first question, is there some reason they were trying not to go to 75,000? My second question is this. The university and Silent Sam always claim that their hands were kind of tied by a statute about disposition of public monuments, what have you. It seemed to me that the solution would have been to go to the legislature and get that statute changed. But was that just politically not possible?
Okay, let me take the first question. The 74,999 does have an important reason behind it, and that is under university policy, the president of the university system has the full authority to settle any matter for less than $75,000 without involving the Board of Governors. Yes. And that's exactly what happened here.
Okay.
And so that's why that number obviously is important. If there'd been any more, they would have had to take it to the governance committee of the Board of Governors and perhaps to the full board, as they did with the larger settlement about a week later. There was an attempt made, I think, one or more of the Orange County members of the General Assembly put in a bill to change that the law about the Confederate statutes, but it went nowhere. So really what happened, the reason that statute wound up not being applied to the Silent Sam, I think, was that, as you know, Silent Sam was removed by force in a demonstration in August of 2018, excuse me. And then the pedestal was ordered removed by Chancellor Folt in early 2019. So it was in the context that the monument was not there. Now there were some voices on the Board of Governors that apparently wanted to require that it be returned. But the one thing that we did find out in the course of this litigation was that by and large, the university system administrators, Dr. Roper, for example, and most of the Board of Governors members had come to the conclusion that it could not go back up on the campus because the threat to public safety was real and serious, and somebody was likely to get seriously hurt, if not killed, if that monument was put back up and became the focal point of potentially violent demonstrations.
Tom Shea has a question.
Thanks. Thanks, lad. Thanks, Hugh. That was a great history lesson. My question has to do with the issue of the previous case that you mentioned about sexual misconduct. Okay. And while I'm in no way exonerating anybody who is guilty of that sort of thing, I guess my question has to do with if I understand you correctly, now these records would be potentially open. And if that information then comes out, is there a due process component or a concern on the part of the kids who had been found guilty? Only because I suspect that the legal piece of the student body process was probably not quite as rigorous as it might be if it had actually gone to court. So that was my question for you.
Okay. Well, first of all, these are not. This is not student courts. These people were found culpable through an administrative process that's very complicated. There's a whole bureaucracy, actually, a Title IX bureaucracy at Chapel Hill and at most other universities these days to deal with all sorts of Title IX issues, of which these are the most serious, of course. The entire process is controversial, frankly, for everybody involved in it. I've heard and spent time talking with people who represented victims in these matters. I've talked to lawyers who represented people accused in these cases. And again, I think my take on it is that this whole process that's been forced on the universities is very unfortunate. I think Jim Woodall's folks in the Orange County District Attorney's Office have a much better track record and experience in handling cases like this. I don't see any reason why rape cases or sexual assault cases should be handled through an administrative process in an educational setting. But that's what goes on. And so it is controversial on both sides. And there have been challenges to it from both sides. That is, from victims who felt their stories were not given credence and they weren't afforded due process, and certainly from students who were found culpable who made the same complaint.
We've got time for one more question, and I think Greg Bradbury has a question.
Thank you.
Can you hear me?
Yep.
Yeah.
Hugh, thank you for a great talk on enlightening all of us, but more specifically, thank you for your life's work and working on this stuff on behalf of everybody. My question is a personal one. When you were in the JAG office in the Navy, did you happen to work with a guy named John Hudson?
Don't think so.
Okay.
No.
He was a high school and college classmate of mine. I think ran the JAG office and ended up being an admiral. But in any event, I just wondered if you know him. Thank you.
Thank you. Thank you for your nice words about my presentation. Appreciate it.
Well, thank you so much for sharing your time with us. It was fantastic, interesting, something that's certainly, a behind the scenes look at a lot of the good things that you're doing to make sure that we have access to information that is
okay. Can I make one parting plea?
Sure.
On behalf, okay. As you know, this is the Duke Carolina rivalry week, and part of the rivalry is a rivalry between the Daily Tar Heel and Duke Chronicle to see which paper can raise the most money. Both of them are, of course, not-for-profit student organizations. Both can use your money, and I'm hoping you'll consider going to the Daily Tar Heel's website and donating to the Daily Tar Heel out of some gratitude for what they've done in these cases. But if you prefer to donate to the Duke Chronicle, that's okay too, because what we really need is good, strong student journalism wherever we find it. And this is a great rivalry that mirrors the great rivalry between the two basketball teams. So I hope you'll support the Daily Tar Heel, but if you have to, support the Chronicle instead.
Well, thank you so much. Wish everybody a happy weekend. Be safe, stay healthy, and go Heels.